Welcome, friends, for this part 9 of our Argue in English with Fluently and Confidently course. So, in this part, we'll see the style of argument of one Supreme Court petition, some vocabulary, some videos, some additional information, and many more things. First, we'll start with the revision of tenses. So, take any verb, any one verb, and complete total for 12 tenses. So, present tense, Manoj Chaudhary, can you take present tense?
I filed the case in the Supreme Court.
Filed, yes. Filed.
Yeah. We filed the case in a Supreme Court. You filed the case in a Supreme Court. You filed the case in a Supreme Court. He files the case in a Supreme Court. She files the case in a Supreme Court. It files the case in a Supreme Court. They file a case in a Supreme Court.
This is present. Simple
This is
present
present.
tense.
Yeah.
Then
Simple
continuous present tense.
Simple. Yeah. I am filing the case in a Supreme Court. We are filing the case in a Supreme Court. You are filing the case in a Supreme Court. You are filing the case in a Supreme Court. He is filing the case in a Supreme Court. She is filing the case in a Supreme Court. It is filing the case in a Supreme Court. They are filing the case in a Supreme Court.
Correct.
Present perfect.
Present perfect.
Yeah. I have filed the case in a Supreme Court. We have filed the case in a Supreme Court. You have filed the case in a Supreme Court. You have filed the case in a Supreme Court. He has filed the case in a Supreme Court. She has filed the case in a Supreme Court. It has filed the case in a Supreme Court. They have filed the case in a Supreme Court.
Correct.
Present perfect continuous.
Correct.
I have been filed a case in a Supreme Court. We have been filing a case in a Supreme Court. You have been filing a case in a Supreme Court. You have been filing a case in a Supreme Court. He has been filing a case in a Supreme Court. She has been filing a case in a Supreme Court. It has been filing a case in a Supreme Court. They have been filing a case in a Supreme Court.
Correct. All 4 tenses of present tense you covered very well. Now, Taso, past tense. Take any verb and demonstrate all 4 subtenses of past tense.
Past, simple past.
Yes.
I filed a case in Supreme Court.
I filed.
I filed the case in Supreme Court. We filed a case in Supreme Court. You file in Supreme Court. She filed in case in Supreme Court. You file a case in Supreme Court. You file a case in Supreme Court. It filed a case in the Supreme Court. They file in the case in Supreme Court.
Yes. Little bit better, but some sequence is changed.
Yes.
Okay.
Yes,
no,
structure is little bit.
Yes. Go in continuous past tense.
Continuous past. I was filed a case in the Supreme Court.
I was filing.
I was filing a case in the Supreme Court. We were filing a case in the Supreme Court.
Correct. You
You were filing a case in the Supreme Court.
Yes.
You were filing a case in Supreme Court. He was filing a case in the Supreme
Correct.
Court. She was filing a case in the Supreme Court. It was filed a case in the Supreme Court, and they were filing the case.
They were filing the case in
They
the
were filing a case in Supreme Court. Yes.
correct. Now, past perfect tense.
Past perfect tense. I had a file case in the Supreme Court.
Correct.
We had filed a case in the Supreme Court. You had the file a case in the Supreme Court.
Yes.
You had filed a case in Supreme Court. He had filed a case in the Supreme Court. She had filed a case in Supreme Court. It had filed a case in Supreme Court. They had filed a case in the Supreme Court. Sir.
Correct. Now, past tense, perfect continuous past tense.
Past perfect. I had been filing a case in the Supreme Court.
Correct.
We had been filing a case in Supreme Court. You had been filing a case in the Supreme Court. You had been filing a case in Supreme Court. He had been filing a case in Supreme Court. She had been filing a case in the Supreme Court. It had been filing a case in Supreme Court. They had been filing a case in Supreme Court, sir.
Correct. Now, Santosh. Future tense. Unmute yourself. Yes, take any work.
Good evening, sir. Good evening, sir.
Good evening, good evening. Take any work and complete 4
Yes, yes.
substances of future tense.
Future tense, right?
Yes.
I prefer to appeal. Appeal. I will file a appeal in Supreme Court. We will file a appeal in Supreme Court. He will file a appeal. He will file a appeal in Supreme Court. She will file a appeal in Supreme Court.
After we,
Sorry, sir. Yes. You will file a appeal in Supreme Court. You will file a appeal in Supreme Court. He will file a appeal in Supreme Court. She will file a appeal in Supreme Court. It will file a appeal in Supreme Court. And they will file appeal in Supreme Court.
Correct.
Then continuous future tense.
Correct.
I will be filing appeal in Supreme Court. We will be filing appeal in Supreme Court. You will be filing appeal in Supreme Court. You will be filing appeal in Supreme Court. He will be filing appeal in Supreme Court. She will be filing appeal in Supreme Court. It will be filing appeal in Supreme Court. They will be filing appeal in Supreme Court. This is a future continuous tense.
Yes.
Now, future perfect tense. Future perfect. I will file appeal in Supreme Court. We will have filed. I will have filed appeal in Supreme Court. We will have filed appeal in Supreme Court. You will have filed appeal in Supreme Court. You will have filed appeal in Supreme Court. He will have filed appeal in Supreme Court. He will have filed appeal in Supreme Court. She will have filed appeal in Supreme Court, and it will have filed appeal in Supreme Court. They will file appeal in Supreme Court.
Correct.
Now, future perfect continuous tense. I will have been filing appeal in Supreme Court. We will have been filing appeal in Supreme Court. You will have been filing a appeal in Supreme Court. You will have been filing a appeal in Supreme Court. He 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 will have been filing a appeal in Supreme Court. She will have been filing a appeal in Supreme Court. It will have been filing a appeal in Supreme Court. They will have been filing a appeal in Supreme Court.
Correct. He, she, it, has, and they have. Correct. Okay. So this is completed. Now we will take vocabulary. I will give today one new video of one senior lawyer,
Okay.
and that video presentation is good in English, and you have to find the difficult words and get the list of difficult words and find out its meanings, because this treasury we are finishing now here. So we have completed this. Now this provocative. Manoj, read, tell meaning, and use in own sentence.
Provocative. It's got a green signal. I will adjourn.
Okay. Yes. Santosh.
Yes, sir. Provocative. It is adjective causing anger or another strong reaction, especially deliberately. A provocative article. Provocative. My friend intentionally provoking me and abusing in front of the people.
Correct. Ekdam, very correct using statement. You have used that word in statement correctly. Then Tasu, queer.
Sir, and which word, sir?
Queer.
You queer. Strangers, he had.
The meaning of queer is strange, or it is in front of you on screen.
Yes. She had a queer feeling they were being watched.
One sentence is there. What is the meaning of queer? Queer.
Good, odd one, na?
Odd or strange.
Okay.
Now use that word into your own sentence. Legal sentence.
Legal sentence. Sir, I have no idea about that sentence.
Use any sentence.
All this submission in the court documents is queer, which is not acceptable by the
Correct. Some documents are in court proceedings are queer, so court will not accept it. Very good.
Sir.
Very good. Envisage.
Envisage.
Envisage. Yes. What is the meaning?
It's going up. It's a verb.
Yes.
Contemplate or conceive of a possibility or describe future event. By looking the merit, we can envisage that we can win the case.
Correct. Santosh, metaphor.
Yes, sir. Metaphor.
Hmm.
Metaphor is a noun, a figure of speech.
Ah,
A figure of speech in which a word or phrase is applied to an object or action to which it is not literally applicable.
ah.
Metaphor.
A figure of
In which
speech in which word or phrase is applied to an object or an action to which it is not literally applicable. That means
the
ah,
the irrelevant document is not metaphor in the court.
correct. Deductive. Manoj. If you are driving, no issue. Ashok, deductive.
Deductive, sir. All the documents submitted.
No, state is tell the meaning first. Deductive.
Okay, sir. Okay. Deductive means, sir, it means which reduced from the this present content, all the content.
Characterized by or based on the interference of particular instances from a general law. Deductive reasoning used my deductive power.
Yes, sir. Then I'll make my own sentence, sir.
Yes.
Deductive, all the documents which is not relevant in the court should be reduced by the honorable court.
Correct. Analogous.
Analogous.
Yes.
Similar. The CLB as per Company Act 1956, NCLT is in analogous to NCLT in 2013.
Okay. Inherently.
Inherently. This is adverb. Its meaning is in a permanent, essential, or characteristic way. The work is inherently dangerous. His theories are inherently Clairvoyantism is inherently threatening.
Correct.
Sir, meaning is not.
You are not getting its meaning?
Yes, it is disappear.
Yes.
Now it is okay. Now it is okay.
Okay.
The subject of Indian Evidence Act is inherently important for the law student.
Okay. Very good. Now I will show you one video which you have to listen at full length at your home. YouTube. First, we have to go to YouTube. No need to waste time. I will share that video on your group. You watch that video and find out the difficult word. Who will take this task? Because you have time. till next Friday, coming Friday. Take responsibility of hearing and finding out the challenging words and its
Yes, sir,
meaning.
I will take.
Okay. Santosh is taking the responsibility of that video. Okay. When what is our next homework? Can anybody tell? Because when we give the so much gap now, that time flow will automatically get reduced. So we should not give any gap now. On next Friday, only one is there, I will take the program. All are there, I will take the program. No issue. But no gap should be there. Otherwise, our flow will get disturbed.
I think on the last occasion, we have to prepare Guru Naz versus Miss Rashmi for the argument. We have to argue on that case. Guru Naz versus Miss Rashmi.
Guru Raj, yes.
HMA
Guru
case.
Raj. And then we have to give opinion, legal opinion on the Amit versus Rani Thomas and others. That
Yes,
is
yes.
judgment of Karnataka High Court.
High Court. I think Bombay High Court. Rani Thomas.
Yeah, Bombay High Court. Nitin Samra
Rani
Justice.
Thomas,
Right?
Bombay High Court. Yes, let me open. Who will give me advice? For consultation argument. I think this is a judgment, I think 12 pages.
12 pages, right?
Yes. Reading 12 pages, reading 15 pages, reading 50% pages, reading 100 pages, it is not possible in our advocacy for giving the advice. But if you start some paragraphs, you can understand the facts of that judgment. What is the problem and what a decision High Court has taken. So according to you, what Rani Thomas comes with you, it means that the decision is in favor of Amit, because Amit is petitioner in High Court. Rani Thomas has come to Supreme Court. We already filed this case. We have already admitted this case in Supreme Court. Because Rani had get defeating reaction from High Court. And Rani comes to us. And now in Supreme Court, Rani versus Amit. Such type of cost title is there. So, give me advice. Have you read it?
Yes, sir, I have read.
Yes, then tell.
I have read total judgment, but it's very difficult to understand what was in that. But I will advise you.
Yes.
As per my knowledge, okay?
Yes. As per your understanding.
Yes. Sir, good evening. I have read your High Court judgment, which is against your against you. I have read the whole judgment. In that judgment, that Honorable High Court, Bombay High Court, has made an error while passing the order, because the respondent, that is you, that is Rani Thomas. Rani Thomas has not consented for withdrawal of the amount of rupees 25 lakhs 50,000 and interest thereon. The High Court, actually the High Court has made error in your case. Why? Because the interest you have to, you are eligible for getting the interest, but the Honorable High Court has made an error, so we can fight for that. Again, in this judgment, respondent has not given an opportunity. That means you have not given an opportunity to express your opinion or reply on the application of withdrawal of the amount with accrued interest.
Yes.
That is the main point. Because judgment after petitioner's point has been considered, but your point has not considered by the High Court. And in this case, the principle of natural justice is applied. Why? Because you have not heard, and the another principle, let the opposite party be heard. It is applicable. This principle is applicable in your case. And I have read that judgment wholly, and I pointed out that point and got that point. And also there is one odd alterum pattern. There is one there is one theory, that is odd alterum pattern. It means let the other side be heard at the time of deciding your application, that is application for withdrawal of interest amount, that is 10,69,000, I think, and that is not considered by the High Court. Therefore, the injustice has been done with you, and it is against the principle of natural justice. So in this case, your fundamental right has been also violated. So we can also come with the fundamental rights, and we can file the appeal in Supreme Court.
We can challenge also that. Yeah.
Yes, we can also challenge that, and we can get justice from the Supreme Court. So I have read your whole case. It is only for the interest amount and nothing else, because already all the process and all the proceeding has been done, and you have filed the purchase also, and all the matters has been settled. But only the matter is that interest on matter is on the interest subject only. So we can get the justice from the Supreme Court, and we can file the appeal.
Very good.
And
Very good try. But out of 100, I can alert you for this understanding and for advising 40 marks, because complete understanding of that particular judgment was not there. Only some part of understanding was there. Manoj, now you advise?
Yeah. This case is versus with Amit and Rani Thomas. Thomas responded, and it was a petition.
Some network issue will be there. Okay, anyway.
Hello.
Yes, yes. Okay. No issue. What happened? Rani purchased row house from one builder. That builder has not given the possession.
Am I audible?
Yes, you are now audible. Huh?
Yeah. Sorry. So even the payment has made in 2013, the possession has given in 2017. So there is a lapse of 4 years. And within the 4 years, a huge interest has been accrued. So the party is able to get the interest as the possession was given with a delay of 4 years, 3 months, and 18 days. So the builder cannot get this interest as one side he has already delayed. So to positiveness he cannot get. So it is in your part that you can get those interest since he has delayed giving the possessions and that. So we can file this case in the Supreme Court and we can win it very well.
Very good understanding. Because of delay in possession, builder lost this case in trial court and decree is in the favor of Rani. But High Court has not considered the properly, and one agreement is there in the High Court. One consent deed was there, and that consent deed we will share it 50-50%. And that consent deed also not considered by the High Court. On the consent deed, on this point, I had admitted this case a few months back in Supreme Court, Rani Thomas. Now that case is in pending. After July, its registry process is going on. After registry process completed, that case will come for after notice hearing. Then we will proceed it in the Supreme Court. So okay, good advice, good understanding. I can give you out of 100, 50 marks for this. Because main facts you should be clear in facts. Remember these 3-point sequence should be there. If you want to become an excellent lawyer of our country, always keep in mind, you should know fact, you should know law point, and you should know case laws. So fact is there. So you should discuss first fact. What is the fact of this case? What are the law points in this case? And what are the supporting case laws for that case? These 3 points are very important. And which point High Court has not considered? Focus on that point. Try to make question of laws on that point. Grounds also. Question of laws and grounds. These 2 things are essential for drafting a SLP. And argument, there should be a substantial question of law. There should be the error done by the High Court. That time that case will get admitted immediately. So on last working day, I think on 19th or 18th of May, on last working day, there was 2 cases of admission hearing of our law firm. And I argued that 2 cases, and both cases get admitted. Both cases get noticed. So such type of things are there when we get complete fact, complete law point, complete case laws. In one case, I argued only for 1 minute, and another case I argued for near about 2 to 4 minutes. But that case got admitted. Now, Guru Raj SLP. What is the time? Okay. Guru Raj SLP. You have to argue for admission hearing. Have you studied that?
Yes, sir.
Okay. Yes, proceed.
Santosh, you continue. After that, I will take.
Yes, continue.
Okay, no problem, no problem.
Okay,
I will continue, sir.
okay.
Shall I proceed, sir?
Yes, yes.
Lordship, we have filed special leave petition against the impugned judgment passed by the Honorable Karnataka High Court.
Impugn judgment.
Impugned judgment passed by the Honorable Karnataka High Court in criminal writ petition number 200068 of 2023 of dated 22nd to 2023. And for the petitioner lordship, in this case, the Honorable High Court has made the error while passing the order, because lordship, respondent who is the Rashmi has suppressed the real and material fact, as respondent was married earlier with some other person, and filing petition under section 125 before the learned family court at Kulaburgi. Even the respondent has failed to submit decree of divorce.
Santosh, just hold 1 minute. I want to add one feature from today onwards. Okay. We have to use one word, pertinent, any word. So I'm giving you word pertinent. Okay.
Pertinent.
And while you are arguing, use maximum type pertinent. Pertinent means in Marathi yogya. Okay, yogya, or in Hindi, you can say it.
It means it is pertinent to note that.
It is pertinent to note that. It is pertinent to say that, like that. So use pertinent word repeatedly, so that, because we are observing vocabulary, but if we not use that vocabulary in significant way, if we don't manifest that vocabulary in our argument, that so we cannot build our language properly. So use pertinent maximum way. Okay, go ahead.
Yes, lordship. In this case, the respondent has failed to submit the decree of divorce of previous marriage before the family court, your lordship, and in spite of petitioner repeated request and application filed before the family court, but the High Court has not considered that applications and interlocutory applications filed before the family court. Lordship, I would like to concentrate on the section 5(1) of the Hindu Marriage Act 1955. That is a condition of marriage of Hindu. Both are the Hindu. That is a condition for the marriage of Hindu. First is, neither party has a spouse living at the time of marriage. Neither party has a spouse living at the time of marriage. Correct. And according to section 11,
that means spouse should not be alive.
Yes, should not be alive.
Spouse is alive, you are not allowed to do the marriage.
Yes, lordship.
Is it
spouse is alive, then the petition which is filed by the wife, filed by the respondent, is not maintainable, and it is not in the correct, or and she is not a legally wedded wife, and she has no right to file the section 125 of CRPC, that is application for maintenance before the family court. According to section 11, your lordship, of Hindu Marriage Act, any marriage is solemnized after the commencement of this act shall be null and void, and may, on the persistence presented by other party thereto, be so declared by the decree of nullity. It means, lordship, the application filed by the party which is null and void, because she is not a legally wedded wife.
Okay.
And after that she filed the petition under section 125 of CRPC before the family court, and she has not complied with the condition of section 5(1) subsection 1 and 5. Section 5 subsection 1 and 5. And with regard this case, Lordship, I am believing and relying upon the judgment Savita Ben Sambabai Bhatia versus State of Gujarat, that is 2005, this court's judgment. In this judgment, it is held that, Lordship, marriage of women, if it is in the accordance with the Hindu writ with a man having a spouse living at the time of marriage, is nullity in the eyes of law. It means, Lordship, in this case also same fact is here, because in the eyes of law the marriage is not valid and it is a null and void. Why? The lady has not get status of legally wedded wife and accordingly not entitled to get a benefit under section 125 of CRPC. Why? Because she is not a legally wedded wife, and she come with the unclean hand before this court, and we have filed the appeal before this Supreme Court. Why? Because she is not a legally wife and she is not a legally she don't have any legally status of the marriage. So, and your Lordship, again another one is judgment I am referring, another one judgment, that is Nimak Yalla Adi Narayanamam versus State of Andhra Pradesh. That is 1970 judgment of this Honorable Court. In that judgment, it is held that it is expedient in the interest of justice that on inquiry to be made. It means in the CRPC section 340, it is clearly stated that when any court is in the opinion that it is expedient in the interest of justice that inquiry should be made in any offense referred to clause B of subsection V of section 195. It means under section 125, inquiry should be made with regard to the case. In this case also, the inquiry should be made because which appears to have been committed in or in relation to a proceeding of the court. Such court may, after such preliminary inquiry, if as it is saying necessary on the record of things, then it should be applicable to our case. This judgment is also very much applicable in our case, and it is attracted to our case. Lordship, at the time of cross-examination, she herself admitted she is previously married with another man. She admitted in cross-examination. And she admitted her previous marriage. Therefore, she has not come with the clean hand, and she has filed the 125 CRPC petition for maintenance is not a lawful, and it is a bad in law. Lordship, if we see the scenario of the case and fact of the case, so there is a question of law. Question of law comes in the mind whether the Honorable High Court ought to have not considered appreciated the settled provision of law with regard to the perjury and suppression of the fact and material as laid by this Honorable Court in the catena of judgment. In this case, your Lordship, that lady also suppressed the fact which is perjury and suspicious, because she already got married with another man, and after the marriage she filed another petition under section 125. That means it is not unlawful and she is not legal wife. Another question is law, whether the impugned order of legally sustainable being passed the contradiction of relevant statutory provision of the law. It means that is impugned order is not sustainable, legally sustainable, and it is statutory provision of law. Another one question, law point arises whether the court below ought not to have appreciated that petitioner has rightly approached the learned trial court by filing applications under section 91 and 340 of CRPC. In our case, your lordship, we have filed application for production of document under section 91 and under section 340. It is not considered, and interlocutory application has been not considered by the lower court also. Hence the error has been made in this case. Another question of law, whether impugned order is legally sustainable being passed in contradiction of relevant statutory provision of law. Another question of law, lordship, the High Court ought
Mr. Consul, say, tell me some strong grounds.
Yes, lordship. Grounds is what? I'm coming on the grounds and I'm believing on the grounds which is related to this case, and I'm believing in the same. The Honorable High Court, Karnataka, has failed to appreciate lenient precedent held by this Honorable Court in judgment Savita Ben Sambabai Bhatia versus State of Gujarat. That is, I explained earlier.
Yes.
And in that case also, the marriage of women, even if it is in accordance with the Hindu rites with man having a spouse living at the time of marriage, it is a nullity in the eyes of law. That is a strong ground. I'm believing on that. And another strong ground is the lady will not get status of legally wedded wife, and accordingly not entitled to get benefit under section 125, because she already admitted in cross examination she has previously married with another man. It is not legally. This is a strong ground, and I'm believing on the same. And another ground is what the Honorable High Court as well as the learned family court have failed to appreciate the essential of section 5 and section 11 of Hindu Marriage Act, which I earlier explained before this Honorable Court. That is a condition of Hindu Marriage Act.
Mr. Consul, what are your prayers?
Lordship, my prayer is grant the special leave petition which is filed against the impugned judgment and final order of 22/2/2023.
Okay. Any interim relief you want?
Yes, your lordship. That lady be restricted to give any information. No, your lordship, I cannot.
Okay. Good try. Out of 100, you will get now today 50 marks. So Manoj, go ahead. We will continue without break. We will continue for near about 30 to 35 minutes only, because after so many gap we are conducting this session. So little bit laziness is there in all of us. Okay. But we will get warming up, and we will continue without any break. Manoj, yes.
Yeah. My lord, I am Manoj Kumar Chaudhary, counsel for the petitioner side. Party are related to the husband and wife. The wife demanding a maintenance of under section 125 of CRPC. The ground of challenge of the impugned judgment ordered 22/2/2013 of the High Court of Karnataka, Telaguru branch. My first submission is that the marriage solemnized between the Guru Raj and Rashmi is null and void under section 5 of HMA, as the respondent has hidden its earlier marriage from the party and the court. Also, this was no question of maintenance, as this marriage itself is null and void. My lord, the respondent is not ready to take the case of old parents-in-laws and asking for a house in own home, which is again seems like a illicit behavior to establish this relationship. My lord, the point raised in the criminal complaint under section 340 of the CRPC and charges framed by the IPC 383, 385, 417, 503, 211, 10, 191, 192, 196, 199, 203, and 499 and 500 for defamation has been dismissed by the family court. So these charges should be again framed against the accused. My lord, the written argument submission which was given in the lower court, which has not been considered and explored. And the only thing which has explored during the cross-examination that she has early married and she has hid that information from the court. So her testimony can be checked again before proceeding further. Kindly with these bullet points, I request the court to admit this SLP for further hearing.
Okay, good. Can you tell me some grounds, strong grounds?
So the ground is well settled with this particular Honorable Supreme Court in a Savabita Sambhai Bharte versus the state of Gujarat in 2005. The marriage of women, even if it is in accordance with the Hindu rituals, with a man having a spouse live at any time of the marriage, is a nullity in the eye of the law. So this judgment itself makes a ground for this. The lady will not be get a status of legally wedding wife and accordingly not entitled for the benefit of section 125 of CRPC.
Okay, what are your prayers?
My prayer is that kindly make this marriage null and void, and for the information hidden by the accused, that should be compensated with the damages. And I will also go for the defamation case against the accused.
Okay. Very good. 50 marks also for today's argument. Taso, can you argue? Do you wish to argue?
Sir, last sessions I was not present due to network issue. Today also we have many network issue. Anyhow, I get, sir. Next time, sir, I will participate in argue.
Sure.
Okay,
And
sir,
one more task which I had given to you in last session. That means to search two company law judgment, which is a dissented and another is allowed. So, can anybody read any one judgment or part of judgment?
Yeah, I have gone through the Cyrus Mistry versus Ratan Tata case.
Very good.
So in this case, particularly Ratan Tata is a former chairman of the Tata Sons and the Tata Group. There were two independent organizations. Cyrus Mistry served as a chairman from 2012 to 2016 for the Tata Groups and one of the director of the Cyrus Investment Private Limited. So he is a director of this company. The Cyrus Investment Private Limited is a non-government company incorporated in 1923, and it is basically looking after the investment advisory board. The time of the events in the December 2012, Cyrus Mistry was appointed as a chairman of Tata Sons Limited and chosen by a selection of a panel of Tata Groups when the Ratan Tata stepped down from the post. When he was down from the chairman, so he has been made the chairman in December 2012. In October 2016, Cyrus Mistry was removed from the post of the chairman of the Tata Sons Limited by the majority of board of the directors for loss of confidence. So the Cyrus Mistry has lost his confidence in the board of director meetings, and that's why his chairmanship has been removed. In February 2017, Cyrus Mistry was removed from the director of the board of the Tata Sons. Then in the next year, he has been removed from the directors. So initially, he was removed from the chairman, then he is removed from the directors. This director was removed from the shareholders voting during the general meeting. Now, Cyrus Mistry files a suit under the section 241 and 242 to 44 of the Company Act 2013 before the NCLT Mumbai, alleging oppression of minority shareholder rights and operational mismanagement of the Tata Sons, as the Tata Cyrus was holding a 2.75% of the shares. That's why he has gone for the minority shareholder 241 and 244. So Tata Sons abused their power. The question which was raised by the Cyrus Mistry was that the Tata Sons has abused the power under few articles, and the Tata Trust exercised control over the Tata Sons board. Removal of the Cyrus Mistry as an executive chairman from the Tata Sons Limited. So he has challenged this point also. He has challenged the certain transactions which has happened from the Tata Group for the Shiva and Sterling Group company. Fraudulently transactions of the 22 crore in Air Asia from the Tata Trust. The losses suffered in the nano car project clearly depicts that the oppressive and of minor shareholders, right, and mismanagement of the Tata Group. The last point here he has raised, the acquisition of Chorus at the overpayment of the Tata Trust. The Tata Trust has made a heavy payment for the purchasing of the Chorus. That point also was raised. Unfortunately, the Cyrus Mistry has lost this case in the NCLT Mumbai, as the NCLT says that these all the that the fact of the case is that since you have been removed from the chairman, it is not a case of oppressive and mismanagement. So again, the Cyrus Mistry has approached to the NCLT in December 2019, and the NCLT has overturned the judgment of the NCLT and asked to give his post from 2017. With this impugned judgment, the Tata Group has came to the Supreme Court.
Yes, yes. So now who you are?
Pardon?
Who you are in this matter?
No, I have just analyzed this case, sir.
Who you are in this matter? Are you a petitioner? Are you Tata Sons, or are you Cyrus Mistry respondent here? Because Cyrus Mistry win from the NCLAT. Okay.
Yeah.
And Tata Sons comes to the Supreme Court.
Yeah.
Okay. So now whether you are Council of Tata Sons, Petitioner Council, or Respondent Council. So accordingly, you have to whenever you want to argue, that time argument time we should keep in that mind. Now you are not arguing, you are just reading a judgment. So
analyzing the judgment.
So that is not applicable here now. But just keep in mind in future, whenever you argue, just first consider who are you, because many times first question judges of Supreme Court are asking, who are you? Okay. So I am Jayprakash Somani. No, who are you? I am petitioner, or I am a respondent.
And for the petitioner.
Yes. Okay. Go ahead.
Actually, I have not done this case on an argument basis. I have done this case on a basis of analysis.
Only narration. Okay, no issue. But you selected very nice case, and you read this way in fantastic way also, and you search out some good points also in from that. Okay. So do you want to add anything?
Lastly, the Supreme Court judgment that came in March 2021, that was pronounced a long-awaited judgment. As the Tata Cyrus Mistri's case, the judgment was pronounced by the bench of Supreme Court headed by CGI S.A. Bobde. The SC observed, the Honorable Supreme Court observed that the removal of a person as a chairman of a company is not an oppressive and mismanagement, as it raised by the Cyrus Mistry. So thus he has lost this case, and the Tata Mistry has, the Tata Group has won this case.
Win the case. Yes, and after that, a review petition was there also. Curative petition was also there. Okay, so both are dismissed in this matter. Okay. Yes. Now, Santosh, read.
Yes, sir. I have searched the cases, but I have not read that.
Okay.
I have searched 3 cases.
Okay.
If you allow me, then I will read the judgment.
Yes, read.
But it is very difficult. 30 or 29 pages.
No. Read only starting part, starting 2 paragraph and ending decision only.
Okay. So I will read.
Yes, that will give you touch of company law.
Yes. The Supreme Court of India Civil Appellate Jurisdiction Civil Appeal 9340 of 2019. Aruna Oswal appellant versus Pankaj Oswal and another respondent with Civil Appeal number 9399 of 2019 and Civil Appeal number 9401 of 2019. The judgment is passed by Honorable Honorable Justice Arun Mishra. This appeal have been preferred against the judgment and order dated 14/11/2019 passed by the National Company Law Appellate Tribunal, New Delhi, for short title NCLT in Company Appeal 80 number 411 of 2018, thereby affirming the order passed by the National Company Law Tribunal for concerning maintainability of application filed under Section 241 and 242 of Company Act 2023. Hereafter refer as the Act. The case is outcome of the family tussle late Mr. Abhay Kumar Oswal during his lifetime held as many as 5,35,03,960 shares in Messrs. Oswal Agro Mills Limited, a listed company. He breathed his last on 29/3/2016 in Russia. On or about 18/6/2015, Mr. Abhay Kumar Oswal filed a nomination according to Section 72 of the Act in favor of Mrs. Aruna Oswal, his wife. 2 witnesses duly attested the nomination in the prescribed manner as per the appellant. It was explicitly provided therein that this nomination shall supersede any prior nomination made by me or us and any testamentary document executed by me and us. The name of Mrs. Aruna Oswal, the appellant, was registered as a holder on 16/4/2016 as against the share held by her deceased husband. Third para, Mr. Pankaj Oswal, respondent number 1, filed a petition seeking partition suit being PS number 53 claiming entitled to 1/4 of the estate of Abhay Kumar Oswal. He claimed 1/4 of the deceased shareholding who was holding shares to extend 39.88 in Oswal Agro Mills Limited. Respondent number 2, the deceased also held 11.11% shares in Messrs. Oswal Greentech Limited. Respondent number 16. The partition suit was filed on 3/2/2017 by the respondent number 1 for 1/4 each of 39.88 shareholding in respondent number 2 company and 11.11 shareholding in respondent number 16 company. Prayer was made for interim injunction in the civil suit. The High Court wide order dated 8/2/2017 directed the party to maintain the status quo concerning shares and other immovable property. As on 8/2/2017, the shares stood registered in the ownership of Mrs. Aruna Oswal, who continues to be a owner of the shares. That is para number 4. After the demise of Abhay Kumar Oswal, respond number 1 entered into the corporate office of respond number 2 and 16 along with his wife, for which a criminal complaint was lodged. FIR number 54 of 2000 was registered at police station Barkamba Road, New Delhi as a counterblast. Respond number 1 also filed a criminal complaint against the appellate as well as the official of respondent number 2 and respond number 16 companies, alleging illegal transmission of shares, and the application filed by the respondent for registration of the FIR was dismissed wide order dated 13/8/2018, and the revision petition filed against the said dismissal is pending. 5 number para, Mr. Pankaj Oswal, respond number 1, filed company petition number 56 CSP PB 2018. Pankaj Oswal,
decision part.
last
Yeah.
para.
The last few paras.
Para number 47.
Yes.
47, just below the 47 para. In the instance case, considering on the unveil of upper said decision, we are satisfied that respond number 1, as pleaded by him, had nothing to do with the affairs of the company and he is not a registered owner. The rights in estate or shares, if any, of the respond number 1 are protected in the civil suit. Thus, we are satisfied that respond number 1 does not represent the body of shareholders holding requisite percentage of shares in the company necessary in order to maintain such a petition. It is also not disputed that the High Court in the pending civil suit passed an order maintaining the status quo considering shareholding and other properties. Because of status quo order, shares have to be held in the name of Mrs. Aruna Oswal until the suit is finally decided. It would be appropriate, given the order passed by the civil court, to treat the shareholding in the name of respondent number 1 by NCLT before ownership rights are finally decided in the civil suit, and properties also demands it. The question of right, title, and interest is essentially adjudication of civil right between the parties. As to the effect of nomination decision in a civil suit is going to govern the parties' rights, it would not be appropriate to entertain these parallel proceedings and give waiver as claim under section 44 before the civil suit decision. Respond number 1 had himself chosen to avail the remedy of civil suit. As such, filing of an application under section 241 to 42 of after that is nothing but an afterthought. The learned serial counsel for the appellant argued that respond number 1, a disgruntled son disowned by family settled in Australia for the last 25 to 30 years, he admittedly did not have anything to do with the affairs of the company. On the other hand, it was vigorously argued by Mr. Siddhartha Dave, learned senior counsel appearing for the respondent, that owing to the rampant COVID-19 pandemic, respond number 1 is in Dubai, be that as it may, merely disowning a son by late father or by the family is not going to deprive him of any right in the property to which he may be otherwise entitled in accordance with the law. The pertinent question needs to be tried in the civil suit and adjudicated finally. It cannot be decided by NCLT in proceeding in question. Hence, we refrain from deciding the aforesaid question raised on behalf of appellant in present proceeding. In the fact and circumstances, it would not be appreciated to permit respond number 1 to continue the proceeding for mismanagement initiated under section 241 to 42 that too in the absence of having 10% shareholding and firmly establishing his right in civil proceeding to the extent he is claiming in the shareholding of the company. We refrain to decide the question finally in this proceeding concerning the effect of nomination, as it being civil dispute cannot be decided in this proceeding, and decision may jeopardize parties' rights and interests in the civil suit with regard to the dispute, as the right, title, and interest in the securities. The finding of the civil court is going to be final, conclusive, and binding on the parties. The decision of such question has to be eschewed in the instant proceeding. It would not be appreciated in the facts and circumstances of the case to grant a waiver to respondent of the requirement under the proviso to section 244 of the Act, as ordered by the NCLT. In prima facie does not appear to be a case operation and mismanagement. Our attention was drawn by the learned civil counsel appearing for the respondent number one to certain company transaction. From transaction simpliciter, it cannot be inferred that it is a case of operation and mismanagement. Para number 20, we are of the opinion that proceeding before NCLT filed under section 241 to 42 of the Act should not be entertained because of the pending civil dispute and considering the minuscule extent of holding 0.03 that to acquired after filing a civil suit in company security of respondent number one. In the fact and circumstances of the instant case, in order to maintain the proceeding, the respondent should not have waited for the decision of the right, title, and interest in the civil suit concerning shares in question. The entitlement of respondent number one is under a cloud of pending civil dispute. We deemed it appropriate to direct the dropping of the proceeding filed before the NCLT regarding operation and mismanagement under section 241 and 242 of the Act, with the liberty to file afresh on all the questions in case of necessity if the suit is decreed in favor of respondent number one and shareholding of the respondent one increases to the extent of 10% required under section 244. We reiterate that we have left all the questions to be decided in the pending civil suit in order passed by the NCLT as well as NCLAT are set aside and appeal are allowed to be opposite extent. We request that civil suit be decided as expeditiously as possible, subject to cooperation by respondent number one party to bear their cost as incurred.
Very good, very nice. Daily read something, daily read judgment loudly at home to get mastery on the pronunciation, to get mastery on your explanation style, your lower voice, your higher voice, your action, your expressions on face should be there while you are arguing before the court. So friends, so this is we have completed the task of our part 9. Now I am giving you task of part 10. You get well prepared and come with well preparation. And I will give you some new things also in part 10. So first task in part 10 is you can write down and then put in our group also. I will discuss first all the parts and then I will give point in writing. Okay. So one electronic evidence, on electronic evidence, one lecture is there of one madam. She is my good friend in Supreme Court. She is coming, she was regularly coming from Bombay High Court to Supreme Court for argument of cyber crime matters. But now she is regular practicing in Supreme Court. So her one lecture, beautiful lecture, I will pass on you. And you all three, 4, 5, whatever students of this batch is there, listen that properly and find out the Santosh will find out the difficult words and he will find out the meaning. But listening, understanding her explanation style, her talking style, it is very attractive. So listen that. And Santosh will find out the words. And that word we will cover in next vocabulary. As early as possible, Santosh, tomorrow, day after tomorrow, okay, you put the list of the difficult words. So everyone will get prepared that for next vocabulary of part 10 at the time of the presentation of part 10. So this is a task 1. Task 2 is you have to read it and you have to explain me. You have to read it and you have to explain me the different jurisdictions of the Supreme Court. You will get all the jurisdiction in Supreme Court Rules 2013. Supreme Court Rules 2013 is on Supreme Court website. You download that. Yeah, you put just on Google Supreme Court Rules 2013 PDF file. You will get that from Supreme Court site. Download that. And Supreme Court procedure also there. 2017 procedure. 2010, I think. 2010 or 2017. I think 2010 procedure was there. Supreme Court procedure. So rules and procedure, 2 documents of Supreme Court practices there. In that document, go in jurisdiction. And I will show you my one video of jurisdiction also. So that will give you glimpse, little bit idea. But read from that part of Supreme Court rules. For instance, I will explain you the all jurisdiction. First jurisdiction of Supreme Court is original jurisdiction. Which original cases are handled by Supreme Court. That is original jurisdiction. Then appellate jurisdiction. PIL like that or original jurisdiction. Dispute between 2 states is original jurisdiction of Supreme Court. Dispute between union and 1 state is original jurisdiction of Supreme Court. Writ petition is original jurisdiction of Supreme Court. PIL also is original jurisdiction of Supreme Court. In appellate jurisdiction, SLPs are there under Article 136 and statutory appeals are there. And when a High Court is giving the certificate of appeal under Article 132, 133, 134, that time also appeal can be filed in Supreme Court. So Article 136, any order you can challenge in the form of SLP, any judicial order you can challenge in the Supreme Court. So these are appellate jurisdiction. Some statutory appeals are there, like NC after NCLAT, appeal comes to the Supreme Court. That is under different sections. Income Tax Tribunal appeal comes to the Supreme Court. RB Tribunal appeal comes to certificate. Because now we have to strengthen our portion now. We have to make powerful portion of part 10, 11, 12, 13, 14, 15 and 16 part we have to cover. So RB matter, I will give you touch. I will give you income tax matter touch. I will give you each and every matter touch, practical touch, which I have. I will give that touch. So you should know which statutory appeals are coming to the Supreme Court. Another jurisdiction is a transfer jurisdiction. From one state to another state, transfer of cases will be done by the Supreme Court. So Supreme Court are doing the transfer under section 25 of CPC for civil matters, under section 406 of CRPC for criminal matters, and some cases of same nature are laying all over the India before different high courts. So under Article 139, Supreme Court can get all cases at itself that in Supreme Court, or they can collect all the cases in one high court. So this type of jurisdiction is called transferred jurisdiction of Supreme Court. Another jurisdiction of Supreme Court is a reference jurisdiction. So income tax tribunal, appellate tribunal chairperson can ask some queries to the Supreme Court under reference jurisdiction. President of India under Article 143. Under Article 143, President of India is referring some issues when a money bill or any money on any bill passed by the Parliament of both session, upper house, lower house means Lok Sabha, upper house means Rajya Sabha, and after that passing any bill, President have to sign. But before signing, if President want to understand its legal some issues in his mind, so he can give the reference. So that is a reference jurisdiction. Giving advice to President by Supreme Court is under reference jurisdiction. But to obey that advice or to reject that advice, that is the discretion of the President. If President has not followed the advice of the Supreme Court cannot put contempt of court on the President. So, because that is a reference jurisdiction. So, Supreme Court cannot put the contempt of court why you have not follow our guidance, suggestions given by, advice given by the Supreme Court. Such type of things will not be happen in reference jurisdiction. Another jurisdiction is a review jurisdiction. Supreme Court can review its own petition. So that review jurisdiction is there under Article 139. Review jurisdiction is there. And one is curate jurisdiction, curate petition, curate jurisdictions. So such type of good jurisdictions are there. So when you read this jurisdiction, read it again and again with examples. Read it from Supreme Court Rules 2013. Read it from Supreme Court procedure. Also, you find either Manoj, find the on website of Supreme Court or on Google and put that PDF file in our group. Okay.
Already I have downloaded. I will send it.
Okay, okay. You send on group. Okay.
Yeah.
So everybody will get and everybody will understand. So this is very great input for part 10 is there, jurisdictions. And I will give you one full bunch of case for argument. Okay. Now you have to argue that case with the perspective of the respondent. Remember that. My full bunch is of petitioner. And you have to find out the negative point of the petitioner. Now you have to have your point, negative point of that petition. When you express, that will be your counter affidavit. Till part 9, you argue as a petitioner or appellant. When statutory appel is coming, we can say appellant. When SLP is there, petitioner, respondent. Now, in that matter, you have to argue as a respondent. So I will send you one full bunch with annexure, everything. Read first High Court order in that. That is impugn order. And which point High Court has not considered. That is your plus point. Because you have to say as a respondent, High Court has rightly decided this case, all this point, like that. And this question of law is not relevant to our case. Grounds are not relevant to our case. Case is liable to dismiss at first instance. Like that powerful argument as a respondent, you have to show that. I have given you the ideas also. Read first impugn judgment find out the where High Court has decided rightly. And yeah. And another one, I will share you one High Court judgment for giving the advice. Okay. For part 9, I am not giving you searching of any judgment. Why I am not giving you searching of judgment? Because I have, instead of that, I have given you the great task of searching of the jurisdiction of Supreme Court matters. So you will be a master in Supreme Court in part 10. Part 10 presentation will be very powerful. We will take that part 10 on Friday with the gap of one break, because our flow will automatically increase. And next date, we will try to follow that next date, provided that my health should be good. If my health should be good, no issue. I am now I am in Pune, and Santosh, I am coming to Mumbai most probably on Thursday. You find out what is the program of Thursday. So my lunch award to Santosh was pending.
Yes,
In
sir.
the first presentation, he argued very well. He explained very well, and I have given him one award. That is a lunch with me. So lunch with me is present. I will send you the GPS location of my Mumbai office, because I'm coming to visit the Mumbai office. Mumbai office on rent, but that lazy vacant that office. Now we have to give that office to another lazy, and for just visit. My broker is there who is looking after that office, and in Parel,
Correct.
it is very near to Parel station. When you come down to Parel, and it is equally distance to the other station also. The other station also, it is walking distance. This is also walking distance from Parel. But Parel is nearer. Parel station is nearer as compared to the other station. And it is on the road, Dr. Babasaheb Ambedkar. And my virtual office of Supreme Court law firm is there. And I will visit there. And if it is not possible for you because of your matters and that, just let me know, sir.
I will come, sir, definitely.
Yes, yes. Then no issue. Then no issue. We'll take lunch today. Lunch थोड़ा सा आगे पीछे हो जाएगा, थोड़ा लेट भी आएगा, कोई problem नहीं. I will reach till 11:30. Okay. I will reach there at 11:30. You reach up to 12:30. No issue. Okay. 12:30 issue. We will talk together. Then we will go for lunch. Yeah, nearby in a restaurant like that. So all task of part 10 I have given you. If you want to share something, if you want to add something, if you want to learn something which is in your mind, you can give me that information. So I can prepare and I can add that point in our part 11, part 12 like that. Do you want to share anything? Yes.
Yes, sir. I had one question. While arguing in murder case, in session court and in high court also, how to argue in murder case? Because I have one matter. Just yesterday, one client has given me matter. So I want to prepare on that.
Secret point is there, whether he have done that murder really or not.
Yes, he has done really.
Really. Okay. Then you can save him on the ground of the break of the chain of evidence. You have to find out the break of the chain of evidence. For that purpose, you have to read charge sheet again and again. Then witness statements again and again. Then witness cross statements again and again. Obviously, you will be the counsel of the accused. Prosecution lawyer will be the counsel of the state or victim. But when there is a break in the chain of evidence, that time benefit of doubt will get created. So on the ground of benefit of doubt, you can get acquittal. So benefit of doubt acquittal is not a clean acquittal. If he is in service and if he is debarred from service because of such type of murder like that, and his service is suspended.
He is a railway constable.
Even though he will get acquittal on behalf of, on the ground of benefit of doubt, his service will not restored yet. But you put the writ petition in High Court after that, after getting acquittal. But that should be a, and I will give one case law for that. Sharas Sarda case. Sharas Sarda case. Sharas Sarda case. You can just type on Google, you will find that. Or in my book also, my criminal matter, criminal 302 criminal matter book is there. In book that I have given that case, Sharas Sarda case. Sharas Sarda case is the landmark case. In that case, Sharas Sarda get acquittal on benefit of the doubt from the Supreme Court. District Court has given him the sentence of death. High Court had confirmed the sentence of death, but Supreme Court gave him an acquittal, not clean acquittal, acquittal on the ground of benefit of the doubt, because of the break of the chain of evidences. So that is the main part of the, and read, my books are very cost effective. 300, 400 rupees books are there on different matters.
If you have that book, then you can carry. I can.
No, you just go on Amazon.
Okay.
Amazon, go on Amazon, Flipkart, type there Jayprakash Somani books. You will find my 50 books now. Now more than 50 we cross. So in that books, you will find the criminal law books, which is related to you. Service law books, company law books, income tax book, all. So
Chawla case is same also, no? That,
yes.
Trial court has convicted and High Court has convicted.
Yes. Chawla case is also one of the most leading case to get acquittal. And Manoj, when you visit to our office for any purpose, my PA Pooja is there in office. Now I am in Pune for 1 month, but Pooja is there. I purchased one book, big commentary book on criminal law acquittals. And that book contains a miracle information of all criminal laws. Not only IPC, money laundering also, NDPS also, how to get acquittal. That. So just you go, but to carry that book at home is not allowed in our office. So she will not allow you to carry out the book, but you sit there, you go through the index, go through some part. So whenever you get the drafting or arguing, that time it will get benefit to you. And service law books also, I have purchased 4 volumes. So that just go through that. And there are so many. Regularly, if you find time, 1 or 2 hours, okay, 4 to 6, like that, 4 to 6. Tell Pooja, जब भी जाएंगे पूजा को फोन करके जाइए. Okay, I'm coming and just to study the books. तो जाइए, बैठिए, पिछला टेबल है हमारा वहां पे आपको बैठने के लिए, सेंटर बीच में एक टेबल, वहां पे बैठिए, टेक द बुक्स, read the books, keep that books again and go ahead. No issue. Okay, so that will be so this is the idea of so but this your input of Mr. Advocate Santosh, you have given me one input to put this matter in 11th or 12th. So how to argue criminal matters, specifically serious criminal matters, heinous criminal matters, whose in matters its punishment should be more than 10 years, life imprisonment, death sentence. Rarest of rare case, death sentence will be awarded. Otherwise, life imprisonment. But life imprisonment is not only confined up to 14 years. Life imprisonment can be given till the end of the life. Without any remission, also such type of order can be passed. But giving the remission in the sentence is in the hands of the governor of the state. Governor cannot give the death sentence into a the governor cannot give the convert death sentence into another sentence. That power is to the only president. Okay, president can, even though after Supreme Court awarded death sentence, after confirming the death sentences by Supreme Court, if President of India thinks fit to acquit him or to reduce his death sentence, they can take decision. But that power is not available to the governor of the state. But governor can remit the sentence, he can reduce the sentence. So there are so many things. If you get defeated, suppose Santosh, in your matter, if you get defeated and that parties get punished and got punishment of 10 years, even though you can motivate him, don't bother. We can go to High Court, we can go to Supreme Court, we will find there and we will take the remission of the sentence. After 50% imprisonment, after suffering the after executing the 50% imprisonment, party can apply for the remission. And if his good behavior pattern is good, everything is good, he will get the remission in sentences. So such type of beautiful strength is there. But and if your client is really innocent, and fraudulently or maliciously is implicated in this matter of 302, that time it is very easy to acquit him, because there should be definitely something or loopholes in cross-examination, chief examination, related witnesses. If only related witnesses are there, that is very bad thing. That is very plus point of yours, acquit law. Independent witnesses should be there. Many times in NDPS matter, only related witnesses are there. Only fabricated witnesses are there, which police creates or policeman creates. No independent punch witnesses, and sometimes punch witnesses get hostile. And when punch witnesses get hostile, that time your client will get the benefit of your doubt. So whether that client is really accused or not, really offender or not, that is not your part. That is the part of judiciary. You have to collect all document, you have to read the all document, you have to find out the proper facts, breaking of the chain of evidences, and find out the fantastic case laws, and with proper presentation, proper analysis, when you put the things before the Honorable High Court or Supreme Court or Session Court, and in your last argument, that time case will be in your hand. So this is the end of today's session. So friends, we'll meet on next Friday at 7 to 9 p.m. with all the preparation of part 10. Thank you. Thank you very much.
Sir, one question.
Next. Thank you.